be good to go. Do you have a PowerPoint or something? Or?
It's right there.
This one?
No, the building.
Right, and then
That's the regular one. Oh, never mind. No, there's a push on there in case. Okay, we started early.
Okay. So they should be able to see. Double check.
All right. Okay, good afternoon, everyone. Thank you for signing on. I'm actually going to start going ahead here. So if you can't hear me, please let me know in the side panel. Send a chat or a question to let me know if you can't hear me. We're going to go ahead and get started. My name is Ellyn Riedl. I am a staff attorney with Maryland Volunteer Lawyers Service, and I'm in our housing and consumer program. So today, the purpose of the webinar today is really to talk about two things: land installment and rent-to-own contracts. And kind of how they function in Maryland, and what advocates should be aware of. So we'll go through a few different things. I have some samples to show you, and then we should have time for questions. Okay, so let's just get started. So today we're going to go through what they actually are, what the Maryland law is, how you can help, and just pitfalls to be aware of. So just to give you some context as to kind of how these contracts come into play and where you might encounter them, these contracts are really a result of the foreclosure crisis. So when banks and mortgage lenders foreclose on homes, they're really not interested in being property owners. As if you work in the mortgage industry or you've defended homeowners in foreclosure, you may already know that. So when they acquire all of these foreclosed properties, they usually want to unload them and unload them quickly. So these large nationwide investor groups formed, and they've been buying properties in bulk from banks and Fannie and Freddie, just large numbers of homes, especially since the foreclosure crisis in 2008. Even through today, Maryland is still one of the top states for mortgage foreclosure in the country. So this is a state that is kind of ripe for the issues that we're going to talk about today. What the investors do, they buy these up, and then usually within months of buying them, they're signing tenants and would-be home buyers into these contracts. The important thing to kind of know is that these investors are really not developers. They're not going into the property and fixing things up or working with the community, to build up the community. It's really not what they're interested in. They're interested in making money. And you'll see how they do that as we get further along. And the biggest problem for advocates, for people like us that are trying to help renters and potential homeowners, is that this is very hard to track. So it's hard to track because these large companies, these big investors, create a lot of subsidiaries, a lot of LLCs, and that may own only one or two properties. And so it's really difficult to kind of track their activity in a state or in a locality because they have so many subsidiaries. So I just have an example up here. Vision Property Management has at least 7 subsidiaries in Baltimore City alone. So that's not even including anywhere outside of the city lines. So that you can see kind of how it becomes difficult for advocates to see the problem and to really track the problem. Okay. And to just give you an idea of the names of some of the national investors, and this is a list that came from the National Consumer Law Center. I mentioned them a few times in this presentation, and if you're interested to learn more or kind of get more in depth on this issue, I'd really encourage you to go to NCLC's website. There's a lot of really great information there. But I list a few of them here just to kind of give you an idea of what the names are in case you've maybe encountered them before. And the companies that are in red are companies that we know operate in Maryland. So Harbor and Vision really being the larger of the two, at least that we've seen, who operate in Maryland. Okay, so a little bit of history on land installment contracts, what they are and kind of what their purpose was. So these were contracts for land. So it's a contract for sale, but it really resembled a lease more so than a normal kind of deed to a property, like when someone would be buying it with a mortgage. So it's kind of created to get around regulations when rent and landlord-tenant law was being developed, to protect tenants and consumers. So, and these were kind of the typical terms that you would see in a land installment contract. There really wasn't a down payment that was due. There was, high or pretty substantial weekly or monthly payments. The buyer took possession of the property just like you would in a lease when the tenant moves into the property, but they don't actually own the property at that point. So a land installment contract, you're signing a contract saying that you're buying the property, but instead of the seller giving you the deed at the beginning and you handing over the purchase price to the seller after you get a mortgage loan, you're actually paying the seller directly. So that's kind of illustrated with the picture at the bottom. So you sign the contract, and the money that you're paying, you're actually paying to the seller, not to a bank. And so you don't actually get the deed until the end of the contract. And these contracts can be 30 years, just like a regular mortgage would be, except that you don't have the deed. So historically, you're not building equity. If the payments were not made, the owner could evict the buyer just like a tenant. So the tenant really wasn't retaining any kind of equity in the property at all. So you can kind of see how this was unfair historically to tenants and to buyers. So in 1951, Maryland passed the Land Installment Contract Act. So, and you can see the cite to it, it's in the Real Property Code. And the act was passed in order to, and quoting this Long v. Burson case, if you want to read about the Maryland history of this, that's a great case to read. But the act was passed in order to kind of recast that contractual relationship. So to change the relationship of the buyer and the seller and the land. So now in Maryland, the buyer has equitable title. So similar to someone who's buying a home with a traditional mortgage. The seller is bare legal title and really is only retaining that legal title in order to enforce the contract, just like they would any other lien on the property. So they really changed things around to create more protections for buyers. So in Maryland, if you look in the statutes, land installment contract is defined in the first bullet point here. So where an interest in the property is sold, but the seller retains title and the purchase price is paid in 5 or more installment payments, excluding the down payment. So it's specific, but it's not. But this could actually include a number of different types of land contracts. And then I just listed a few kind of highlights of the act. So it protects the equity. It limits the ability of sellers to eject immediately upon default, and that's a really big deal. So instead of being able to evict someone, a buyer in a land installment contract, like they would a tenant, the seller actually has to foreclose on the lien like they would on a homeowner in mortgage foreclosure. They actually have to go through the mortgage foreclosure process. So in Maryland, a buyer in a land installment contract is going to have those protections of the same protections as homeowners. So the ability to potentially have loss mitigation, the ability to have mediation, and all the notices that a homeowner would get in mortgage foreclosure. So that's a pretty big deal. A couple of other things, if the seller actually goes through with the foreclosure, at the end of it, the buyer is actually entitled to surplus funds. So if the foreclosure sale covers the purchase price in the contract and there's money left over, the buyer is actually entitled to get that back. And just a couple of other things, in the act, the vendor is obligated to give a signed copy to the purchaser within 15 days of signing it, and also give receipts for any payment or deposits made. They also have to record the contract in land records. this is a really big deal as well, because if the vendor fails to record, like it says here, it gives the purchaser an unconditional right to cancel the contract and get an immediate refund of all of their payments. And there's case law that I quote, that I have up there underneath, where it says there's no offset for fair market rental value. So that's a really strong deterrent for someone a vendor who may enter into one of these contracts to fail to record it. It also, if they don't record the contract, they also don't have the right to go through and kick the person out the way that they should be. So it actually, not recording the contract really is a huge disadvantage to the vendor. So a couple of other things, periodic statements. They are required to send statements to a purchaser. And you can see up here when they're supposed to send them and the contents of the statements. But if they violate these provisions, it actually does not make the contract void or voidable. So even if they're not getting statements, that's not necessarily a reason that the buyer or the purchaser could rescind the contract. But these violations could be evidence of maybe operating in bad faith to support a claim of unfair and deceptive practices. So it's not nothing, but this really doesn't have the kind of teeth that the other provisions have. Okay, and with defaults, there is a right to cure. So if the purchaser defaults but is able to cure that default before the vendor starts the foreclosure proceedings, the contract is going to continue. And again, if the purchaser defaults, the vendor has to foreclose rather than eject or evict them. And if the vendor is violating the contract, the purchaser can file in a court of equity, so to enforce the provisions of the act, and just listed up there is a little bit more of information about that. Okay, so I'm going to kind of switch gears here and just explain a little bit about lease purchase contracts, or well, let me get to that slide. Lease purchase contracts or rent to own. So I think, and because there is actually a fairly strong law on the books with land installment contracts in Maryland, I don't think you're going to see land installment contracts as often. What we see and what I think you will likely see more of are these rent to own or lease purchase or lease option contracts. Because there is not a strong law on the books in Maryland about these contracts. So generally, it's really just a lease. It's a lease that has an option contract or option agreement added onto it or added into the body of the contract. And so an option contract, if you're not sure what that is, it's the tenant or the person signing the lease is really just paying for the opportunity to purchase the home at some point in the future and under certain conditions. Usually it allows for part of the rent payments to count towards their down payment on the property. And if the tenant can't or chooses not to exercise the option, then the option's forfeited. And usually that also means that any down payments that they make or any of the rent payments that were going towards the down payment, all of that is forfeited. They don't get that back. So you can kind of start to see some of the potential pitfalls for tenants and would-be home buyers to kind of get into a deal like this where they think they're buying the home, they're actually not buying the home. And the graphic at the bottom is kind of trying to illustrate that in contrast to the land installment contract deal. So you're signing the lease, and then at the end of some period of time, you're either going to convert to a seller financed deal, which would really be a land installment contract, or you have the option of finding outside financing, traditional financing, and just purchasing the home outright. So then you would have a mortgage, but you would get the deed at that point. you hear us now? Okay, can you hear us now? Okay. I'm going to go ahead and continue. I apologize if there was an issue with the audio. Hopefully that didn't go back too far. If it did, we are recording this, so you will be able to access the recording later. Hopefully.
Robin, can you tell us how far back the audio stopped?
Okay, well, we'll go back and we'll check the recording.
When you went to the lease, she was saying.
Okay, great. So just to kind of recap, in case you couldn't hear the audio, if I can get to the top. Okay, so just pointing out, these two paragraphs are really where most of my comments were directed. So this is an agreement. It's a lease agreement, and at some point the tenant has the option to purchase the property for $32,000. When I looked at this property on SDAT, it was only assessed at about $15,000. So this contract to buy was the purchase price was twice what the property was assessed at, and it was more times over what they actually paid for it. So they paid even less than that for the property. So this $750 was the option consideration, and then this particular contract, the option consideration, and then $24.85 of each monthly rent payment go towards the purchase price, the down payment on the purchase price for the tenant if they eventually decide to exercise the option. But the point that I was making with that is $24.85 is not that much money. And this contract is for 7 years. Even at 7 years, there's no mention of interest or anything like that. So even with 7 years, and all of those monthly payments of $24.85, that's not going to add up to the amount of money that they would need under this option to be able to actually purchase the property. So what that means is that this first option, the option to convert to seller financing, is really not an option for a tenant unless they can come up with a really big chunk of outside money somehow. And I really only see someone trying to do this first option if they can't qualify for traditional financing. And like I said, that's a lot of the folks that are going to get into these contracts in the first place. So if they can't access traditional financing when they sign the contract, they may not be able to do that down the road either. Let's see. And so a couple of other things that I was pointing out in this contract, this is really just the explaining what happens if they forfeit the option to buy, if they can't actually buy the property. Then when you look down here, this is really a big issue here as well. So the as is where is clause. It really directly conflicts with landlord-tenant law in Maryland, because in Maryland, the landlord is really responsible for maintaining the property in a habitable condition. But these paragraphs specifically state in a few different ways that the tenant is responsible for all maintenance and upkeep, including making the property habitable. And in this paragraph, it's actually saying that the tenant is promising not to occupy the property until it's brought to a habitable condition. And so, the examples that I talked about before and the picture that you saw with, the roof falling down, water pipes leaking, mold, lead paint, all of those things, the seller is trying to push off onto the tenant and or potential buyer here. And there's actually, and again, there's no inspection with this, no home inspection like you would see in a normal contract, a normal property sale. So there are a lot of potential pitfalls, for renters and potential buyers with these contracts. So this is a few more pages long, but those were really the main points that I wanted to show you. So I'm going to get back to the PowerPoint here. So I'm going to talk a little bit about, we talked about recent developments in Maryland. I'm also going to talk a little bit about recent developments nationally, and kind of highlight a couple of cases that are ongoing. So in 2017, there was news, a lot of news outlets covered this, that Fannie Mae stopped selling foreclosed homes to Vision property because there were so many issues and people were complaining and lawsuits were being filed. Fannie Mae made the decision to stop selling to Vision, which is one of the really, really big players nationally and in Maryland. And so a couple of these other cases that might be interesting for you to follow. The Fair Housing Center of Central Indiana filed a lawsuit against this gentleman, Marshall Welton, who runs a number of LLCs and companies in Indiana, but kind of under this umbrella called Casas Baratas Aquí. So just based on that, you may be able to figure out that this gentleman and his companies were targeting Latino communities and Spanish-speaking individuals in Indiana and around Indianapolis specifically. So there is actually, this complaint is mainly a fair housing complaint. And so you can actually, I have an address where you can look up the complaint if you'd like. And because of this case being filed, Freddie Mac is apparently now examining a loan that they actually gave to this guy and his companies. And the purpose of the loan was to buy properties to create affordable housing. But that loan actually specifically stated that they were not to use land installment and rent to own contracts, and that's exactly what they've been doing. So they are also under investigation from Freddie Mac now with that issue. So kind of moving on to the next one, Horn versus Harbor Portfolio. This is in Georgia. And one of the attorneys in this case representing the plaintiffs, representing the renters/buyer, is an attorney with NCLC and Atlanta Legal Aid. So this is someone who actually helped write some of the NCLC manuals on this issue. So it'll be a really interesting case to follow. And I just listed where the claims are coming from. So fair housing, credit, the state fair housing acts, the TILA, so truth in lending, and you can see some of the other ones there too. I also provided the link to the complaint there as well. And then the last one, the Wisconsin Attorney General's Office has sued Vision Property Management for a lot of the same things. So all the things that we've been talking about are all issues in these cases, in all three of these cases. So this last one is actually a state case. The other two are federal cases. This is a state case that may be an interesting one to follow as well. So strategies for advocates, what can we do to help people who are potentially in this situation or who already are? I mean, we all know that prevention is the best medicine. If you encounter people, potential homeowners or potential home buyers who can't get traditional financing and are looking at this, really encourage them to sit down and crunch the numbers. A lot of these companies operate by pressuring people and saying, there's a lot of people that are looking at this house. You should sign the contract soon, or this house might be gone. And using those types of tactics to get people to sign contracts without really having the time to look at it and evaluate it, and maybe take it to legal counsel to have them evaluated as well. So. And I also see housing counselors being a really important partner in this. We did a panel on this for a conference recently, and one of the speakers on the panel was a housing counselor, and she has encountered these issues a lot. especially with non-English speaking populations. They're especially vulnerable to this because there's the pressure, the intense pressure, the desire to buy a home, and then, the additional barrier of language. So it's really important, especially in those situations, to counsel people about the potential pitfalls before they sign the contract. Now, if they come to you and they've already signed the contract, most of the provisions in state law that may protect them really are based on rescission and voiding the contract, which can be good, again, like I said, if someone wants to leave. But if they don't want to leave and they actually want the home, it gets a lot more complicated. So I just listed a couple of other ideas here. Unfair and deceptive practices and under the Maryland Consumer Protection Act, maybe. Common law contract defenses are always potentially available. And then federally, the Fair Housing Act, I think, fits pretty well with what's going on with these types of contracts generally. RESPA and TILA are going to be a little more complicated because you have to prove first that the landlord or the seller comes under those laws. So you have to meet they have to meet the definition for in TILA, they have to meet the definition of creditor. And RESPA is really for federally related mortgage loans, and so that it's a little bit more. It may be a little bit more difficult to make those connections, especially with RESPA. TILA, you may be able to make the connection a little bit easier. So if you're interested in finding out more especially about the federal laws that you could potentially use to help clients in these situations, I would really encourage you, again, to go to NCLC, their manuals. They have webinars, and they also do conferences every year. The one specific thing that I would point you toward on their website is the Toxic Transactions Report that they did in July 2016. And the link is right there. But if you go onto NCLC's website, there's a publications tab you can click on, and you can find it that way too. If you encounter someone who's potentially thinking about this, and it's a client or a potential client, you can point them towards People Law Library. People's Law Library does a great job of explaining the law in plain language, and they actually have a page on lease option agreements. So it explains what they are, what the Maryland law is on them, and a few things to be aware of. So it can be a good resource for you as you're talking to clients, or to kind of point people toward. And then, of course, the last resource I'm going to list is MVLS. So if you've encountered this or you see other issues, we would love to talk to you about it. We're doing more research on this issue over the summer, and so if you're interested in getting involved, please let us know. We'd love to work with you. Okay, so that's going to conclude my portion of the webinar. We still got lots of time for questions if anyone has questions. I'm just going to go through a couple of things, a couple of the last slides here, just to let you all know. If you don't know, if you go to our website, there are a lot of resources available for our volunteers. So not only can you see the available cases that we have, you can also go to the Attorney Resources page and you can see our handbook. There's sample representation agreements, and there's a lot of other helpful documents there to help you if you're representing an MVLS client. And then just letting you know, there are a couple of upcoming trainings on June 21st. So these are actually out of order. June 12th, Tax Topic Tuesday, is going to be covering startups and tax planning for small businesses. So, and then June 21st is how the new federal tax law is going to affect family law cases. That should be quite interesting. So I'd encourage you to register for those. If you go to mvlslaw.org/events, you can sign up for either or both. And then last, this is the same slide that I had at the beginning, but make sure you're following us on social media if you're not already. And thank you all for joining me, and I'm going to check and see if I have any questions.
Well, Ellyn, I actually have a question for you.
Sure, Amy.
So can you talk a little bit about the kind of cases that you see in that are related to this, that are ancillary, like on a collection docket?
Sure. Yeah. So actually, one of the ways that our organization became interested in this issue was because, we started seeing on the collections docket, actually on the affidavit docket in Baltimore City, but on the collections docket, we were seeing Vision Property Management suing people for post-move out damages. And the vast majority of the damages claimed were, damage to the property. Typically was not a whole lot of rent being claimed due. It was mostly damage to property, saying that, the tenant had damaged all of these things and we had to pay to fix them and it's above normal wear and tear. But they were some really massive issues. And when we talked to the folks who were being sued, it really became apparent that these were problems that were happening before they moved in and when they moved in. So this was not a situation where the tenant caused damage. So that was one way we kind of came upon this issue. The other way was actually through tax sale, where we had a client contact us for tax sale assistance because he said his home went into tax sale, but when we looked into it, it actually wasn't his home. His name was not on the deed to the property. He thought he had bought the home because he had entered into one of these contracts. But unfortunately for him, there really wasn't a lot of recourse for him. He really wanted to keep the home. But like I was saying in the main presentation, that's not always an option for someone in his position. Most of the time, the option is to just void the contract and walk away. So those two things really kind of sparked our interest in this. Any other questions? Comments? Okay. Going once, going twice. All right. Thank you all so much for joining us. If you have any questions or comments afterward, there should be a questionnaire for you to fill out after this is over. Please fill it out and give us feedback. We love to get feedback, and we do actually look at it. I promise you, and it helps us to plan future webinars and future trainings. So it is really helpful for us to have the information. So thank you in advance for filling that out, and thank you for joining us today.